but it is unreasonable. The charge sheet is in the direction of something that we can prove. So you're being told, yes, there's nothing threatening, there's nothing insulting, there's nothing offensive, but nonetheless, let her take plea, we will move along and see what we will do along the way.
I hope we didn't say that. I hope the record will help us.
Let's move. We'll learn where we find ourselves. We'll decline that invitation and find that this is not a proper charge that the person before you should take care.
Thank you. Well, I will be brief, and I will start by quoting Justice Odunga in Republic versus Director of Public Prosecutions and another, Spate Chamanlal Kamani, whereby Justice Odunga said this: the seat of justice is a hallowed place and ought to be preserved for those matters in which the protagonists have a conviction and stand a chance of seeing the light of day. And he adds and says that a trial is neither a showbiz nor a catwalk. Why am I saying this, Your Honor? The DPP under Article 157 has the prerogative to charge. Then again, it is not for sport. It must be exercised reasonably, lawfully, and within the constitutional bounds. The DPP, the office of the DPP, is assumed to be sane and rational. We operate on the gracious presumption that the office of the DPP is sane. But the prerogative to charge, Your Honor, isn't a license to experiment. What, Your Honor, we are telling you is that you don't need to taste the meal to know that something is off. Even the smell of it can tell you that there is something that is off. Finally, Your Honor, two issues. We are not asking the court to test the evidence. What we are inviting the court to do is to test the lawfulness and the sufficiency of the charges. Simple. A criminal trial is only justified where there is a properly framed charge that discloses an offensive law. So we are not saying that we should call witnesses right now. All we are saying is that the DPP has that burden of telling us that these charges are lawful and within the bounds of the Constitution. Secondly, Your Honor, a trial is not a fishing expedition. The charge must disclose a known offense with clear particulars and connect the accused's conduct to that offense from the get-go. If it fails these basic tests, then the charge collapses on its own weight. An accused person must be informed of the charges with sufficient detail. So, what we are saying is that the accused person ought to have known how her words amounted to offensive conduct under Section 94, which is not the case. If the DPP can't say that, then the court is decided to stop. In short and in conclusion, we are not challenging the evidence. what we are challenging is the charge's existence as a valid document. If they insist on going to trial without a valid charge, and that's like building a house without a foundation. Circumstances submit that charge is effective, and this person should be admitted to a personal cognizance. Yes. And they have considered to that. To have been released.
I just wanted to mention an authority.
Yes. So just share with us so that we can also assist the court.
Could I give the citation? Yes. Your Honor, the decision I'm talking about is the Supreme Court decision. The bench comprising of Baraga CJ, Ibrahim Ojuang, Panjala, and Joki. And the case is Hussein with a double S, Hussein Khalid with a KH, and 16 others versus the Attorney General and 2 others. The citation is petition number 21 of 2017. And without making the arguments, it is in respect of this court's powers to enforce fundamental rights. So I'll refer the court to paragraph 118 and paragraph 120. If you allow me to just read. Paragraph 118. While that was the law then, the Magistrates Court Act number 26 of 2015 has since been enacted to give effect to Articles 23(2) and 169(1)(a) and 2 of the Constitution, to confer jurisdiction, functions, and powers on the Magistrates Courts, to provide for the procedure of the Magistrates Courts and for connected purposes. Section 8 of the said Act vests jurisdiction in the Magistrates Court to hear and determine applications for enforcement of constitutional rights, but limited only to claims on freedom from torture and cruel, inhuman, or degrading treatment or punishment, and freedom from slavery or servitude, as guaranteed in Article 25(a) and (b) of the Constitution. The jurisdiction of the Magistrates Court does not also extend to determination of claims for compensation for loss or damage suffered in consequence of a violation, infringement, denial of a right or fundamental freedom in the Bill of Rights. 120. We therefore find and hold that there is now legislation that provides on how magistrates courts may determine allegations of infringement of fundamental rights. Though limited, the same is constitutional as an aggrieved person, while he might not on all allegations approach the Magistrates Court, still has recourse to the High Court, which is the court constitutionally empowered to address allegations or violations of the Bill of Rights. I thank you.
So I must say that that authority, you said that it is open cited. Yeah, it's open in our corridors. Yeah? So thank you for that authority.
Yeah, but just to distinguish it, on one point, and I agree we are bound by the decision of the Supreme Court, but will you not, in a very few minutes to come, enforce Article 49?
That one actually, I was about to say that. You thought, you actually thought in my mind.
We must, I will be seated where you are seated very soon.
I wish you that. Alright. So I want to appreciate the Council for such erudite submission and the decorum, the propriety. I want to thank you most sincerely. You've made extensive arguments and you cited authorities. We've not had a chance to look at those authorities in the case laws. And also we've cited so many provisions of the Constitution together with the statutory provisions we've cited. So I'll request that I'll defer the ruling on that application to a later date. But we can now, as Mr. Jeru had indicated now, go to the issue of the accused person being either released, which is not opposed, I'm told. In the meantime, as we wait for the court to make a determination on the application. I believe that's agreeable.
Yes, that's agreeable. The court can determine whatever terms and conditions.
So to that end, I think I'm alive to the provisions of Article 49(2) of the Constitution. So to give effect to that, I'll release the accused person to a personal bond for 50,000. So the accused person will release a personal bond for 50,000 pending the determination of the application that we just had. Next week, I'm swamped with so many matters that usually I put my wedding in 2 days, but unfortunately next week I'm not, so I'll do the other week after next week. So that on the 29th, so I'm proposing if 29th is convenient, we can come back on 29th at 9 a.m. If it's convenient.
Could we do it on first now that the accused will be out on board?
Yes, first is public, it's amenable to all the parties. So let's first of all I do on the day.
Propose 11th of August. You know, we have a
in the absence of a new culture, I should assume I've taken the role. And I request more convenient for very complex. Yes, I will propose 6 proposal of the site, the 11th, there is a date that appears to be more convenient for your council.
We could go back to the 29th if we continue to that.
The earlier the better.
Yeah. My colleagues will represent.
So if 29th is okay, usually as soon as the better. 29th.
We also agree that we give us the discussion and then we are planning another hour other than 9.
Okay.
Let's say 11.
So we have it and then my last request, cancel the five sabotage. It will be kind enough to say so that I don't get, I get a different authority like the one you relied on. So we know that it's been changing. So
They should also ensure they serve us so that in case.
so just submit it to us maybe by Monday.
No, we don't have a problem of exchanging and filing with you. What I'm reminding them is that whatever they give to you, they
should also share with you.
they should give us, if there is something that we pretty compelling, we could put in a comment. Yes.
So I think just exchange your submissions.
I think because of my years of practice,
Yes.
I'm not betting this where council says I have to give the undertaking before the court. When I'm already telling you we will exchange.
You're like, so I like that. I just say that. That's what you don't say you give us.
Yeah.
And it's been harmed.
Yeah.
The links are very compatible. Yeah, so
Thank you again, and I wish you all a blessed day.
Raha tupate na